meeting is recording now, so I think we can then proceed. The presentations will be made available on YouTube once we have completed this, but please don't see this as an opportunity not to attend today and tomorrow. I think it is more insightful to actually raise any questions during the presentations. I saw somebody's hand raised, but it's disappeared now. If there is any question, you're welcome to speak up. Okay, doesn't seem like it. Unfortunately, the presentation itself in PowerPoint doesn't work across MS Teams. So we'll be using the PDF, and unfortunately, there won't be any of the fun animations and videos that I wanted to show you. But this will suffice for now. I think most of you do have the PowerPoint presentation at hand anyways. Okay, so just to start off, there are my contact details. For those that have just joined, as I mentioned, my name is Marco, and I'm the Senior Associate at Spoor & Fisher and a patent attorney here. For the study material, the most important, your holy book for this module will be the Patents Act. That will be your first and most important source of material for the exam, as well as the patent regulations. Please do make sure that you have the most recent and updated and amended versions of the legislation. Then, as a very nice, simple guide for not just for this module, but for all the IP modules, is the Introduction to IP Law, which is the Dean and Dyer book. This book was authored by a lot of the practitioners at Spoor & Fisher, and I'm not trying to punt this book, but it really is a very useful guide to turn to this book for a basic introduction of the various topics of intellectual property law. And just to give you an overview, that's the book, yeah. Okay, so if you are interested, please see if you can get a copy of this, not just for this module, but if you are practicing, it is a very nice go-to. And then for a very detailed analysis of patent law will then be your Burrell's. I unfortunately have the 3rd edition, but there is a 4th edition available. It's not compulsory, but if you are unsure of any of the topics that we're going to cover, you will need to turn to Burrell's if necessary. Then you'll also notice in the email that I sent through to you, I provided you with 2 articles. There might be some more that come before the exam, but it is unlikely. Just on some interesting topics that are covered in patent law. And those 2 articles are articles that I authored and that were published. So just some additional studying material. And if you had a look at last year's paper, you'll see that one of the questions was focused largely on the one article that was published by the World Intellectual Property Review. And then there is some case law. Previously, before I started lecturing this module, there wasn't any case law being examined. But I have brought in a little bit of case law into the module that you just need to be familiar with. Not in too much detail, rather just what the cases have held, what the findings were, a brief understanding of what the facts were and what the topic was about the issue that the courts looked at and decided on. But all these citations are provided in the presentation. And then obviously the notes that I have provided, this presentation itself is very comprehensive. And if you understand the presentation, if you work through all the material in the presentation, you should be okay to pass the exam. Okay, so before we kick off, it's always good to have a bit of understanding what it is we're dealing with, where it comes from. And as you can see, the first slide that we're looking at now is from Renaissance Italy, and I'm very proud of my Italian heritage and my South African heritage. So it makes me very happy to see that patent law originated in Venice in Italy. And why I've put this slide up regarding their history is because of the extract that we'll work through in front of us now, and how analogous it is to the current patent law and the crux of patent law in South Africa and globally, for a matter of fact. So the first patent that was issued was in 1416, and that was granted to Franciscus Petri in Venice. And he had devised an invention used to full fabric, so to fluff the wool and to use it to make fabrics. And then in 1421, during Renaissance Italy, there was a lot of architecture going on, a lot of development, particularly in Venice and in Florence. So there were a lot of architects that were competing with each other. And so Filippo Brunelleschi, he wanted protection for his invention, which was a new type of boat, which was used to move marble slabs along the canals of Venice. And that was granted to him as a intellectual property, or patent right rather, in 1421. Then if we move on to the next block on the right, this was the first form of the codified patent law, which was promulgated in 1474, which was known as the Statutes of Industrial Brevets. And as I said, that was the earliest codified patent system in the world, which came from Renaissance Italy. There were other forms of monopolies that were granted prior to this, for recipes, for instance. Then there was a move towards English law, where the Crown would also grant monopolies for certain inventions. But the first codified form of patent law comes from 1474, so nearly 600 years ago. And what this held was, if we read this extract quickly, is that each person will make in the city any new ingenious contrivance not used heretofore in our dominion, as soon as it is reduced to perfection so that it can be used and exercised, shall give notice, it being forbidden to any other to make any other contrivance in the form and resemblance thereof without the consent and license of the author up to 10 years, who shall infringe be forced to pay him the sum of 100 ducats, and the contrivance immediately destroyed. So the reason why I put this up is to show you that distinction, or the similarity rather, between what was held in 1474 and what section 25(1) of the current South African Patents Act holds. So as you can see, what the requirement here is that the invention has to be new, the contrivance needs to be new, an ingenious new contrivance. So that's your first requirement of patentability, is it has to be new. Your invention must be new. That's not been made anywhere before in that territory. So as you can see, it's a territorial right, again, that's granted, as with all forms of intellectual property, but it hasn't been made before. So again, this emphasizes the novelty requirement of patentability. And it must have the capability of being used and exercised, so your utility requirement of your invention being able to be used. And it forbids anyone from exploiting that invention without granting an actual license. So you can see some contractual law coming into play already there as well in terms of patents, where nobody could use it without the license or consent from the owner of that patent. And if you do infringe, then you have to pay the 100 ducats. So your remedies also existed back then, and also the destruction of any infringing article. So very interesting to see from 1474 to the patent law that we have now, although obviously far more in depth in today's laws, but it covers the crux of patent law. This is just an illustration of what the statute looked like that was granted in 1474 in Venice. And just having a look again at some of the interesting inventions that have come to the fore throughout history. This is just for your own interest and knowledge, but the purpose of the patent system is to drive innovation, to allow for the development of new technologies to take place. And The Edison light bulb in front of you is a prime example of that. You know, it was a very basic article. You know, you had your glass bulb with the filament running through it, and then you would run a current through it and create this incandescence. And as you can see, this was patented in the United States in 1880 already. But as I said, this disclosure of this invention has led to the innovation and technology that led to the light bulbs that we use today. You know, if you think of your xenon lights or LED lights that are low emitting diodes and using low electricity from what we had there. If it wasn't for this disclosure of this patent back in 1880, we might not be where we are today. And that's just the point that I'm trying to make by this illustration here, is that it is very important to have this disclosure to allow for the innovation to take place. And just a few other fun examples to have a look at. The first one on the left is, can anybody tell me what that is? Okay, I need to hear some voices. Kagiso?
Is that
What is that?
Lego?
Yes, that's the Lego brick. Okay, so again, remember, I'm sure you all have this hashed into your heads already, the rights are territorial in nature, therefore limited monopoly. And that was the patent that was granted for the Lego brick back in 1958. Okay, so that patent has expired a long time ago. Across the world, your monopoly is generally for 20 years. So that would have expired already. But what is interesting about the Lego brick is that it is so recognizable, as you pointed out, Kahi. So you immediately saw that that is a Lego brick. Can you think of any other form of intellectual property that might still exist on that Lego brick today? Okay, we're the trademark practitioners here. It's a shape mark, yes. Kahiso?
Oh, you just said it.
Yeah, okay. Charmaine, do you want to comment?
Hi, I was going to say design.
Okay, so you're right. They could, at that time, it would have been a design possible to have a design registration as well for the shape and configuration. But for design law, that aesthetic design is only limited to a 10-year monopoly. But that is very right. At the time that that was devised, there could have been a design registration for that as well. But you must also remember that trademarks also allow for a shape mark. And that was what I was alluding to, is that it's so recognizable, this Lego brick, that there is a possibility of a trademark existing for the shape mark, which is the Lego brick. And as you know, you can extend the existence of a trademark into perpetuity, provided the renewal fees have been paid. So although the patent has expired, Lego can still exploit their monopoly for the trademark itself. So that's something that you must always look at when you're looking at a product, or if you are in practice advising a client on their intellectual property, not to just focus on whether it's a patent or whether it's a design or trademark. There's often overlap between the various forms of intellectual property. And you'll be doing a disservice to your client if you don't break it down and see how best can I protect this intellectual property. Okay, and then in the middle we have the Gillette razor. I was forced to shave this morning because I'm looking at all of you, so I made use of that this morning. Again, something from 1904, and then the first manned flying aircraft, which was granted to the Wright brothers in 1906. So just some very cool patents, hopefully to whet your palate a little bit for intellectual property law and patents in particular. So if we bring this a bit more closer to South Africa, to Mzansi, some very cool inventions that have come out of South Africa. The one on the left is your Pratley Putty, which was used on the Apollo 11 landing. I think it was Apollo 11 for the moon landing. Okay, that was used, that went out to space, a South African invention that went to space. So very, very cool. Then you have the CT scanner, also a very cool South African invention, Q20, the creepy crawly. And then I don't know if anyone knows what the dolos is, the one with the South African flag on it at the bottom here. So that's basically a wave breaker to prevent erosion of the land. So you'll see along the coast, particularly at the harbors and things, these doloses are used. Unfortunately, there was no patent ever applied for the dollar, so all the rights were lost here and for free access, unfortunately. But I mean, it is used across the world. So had they actually sought patent protection, I'm sure the proprietors of that invention would have been multimillionaires by now. So just very cool South African inventions. South Africa is very innovative in some ways, and I think we should always encourage our inventors that we deal with to continue with their innovation, continue developing, and to get their names out there and globally recognized. I mean, if you think more recently, about 2 years back, the first ear transplant with the 3D printed products for the hammer and anvil used in the ear, which was done here in Pretoria at Steve Biko Hospital. So a lot of very cool development that does take place in South Africa as well. So I don't think because we probably consider a third world country that we're not striving for innovation. We actually have very cool products out there in the world. Okay, there's very interesting books on South African innovation as well. So if you are interested, let me know and I'll give you the references for those books. Charmaine, I see your hand is still up. Do you have a question or is that from earlier?
Oh, sorry, it's from earlier.
Okay, that's fine. Okay, just to quickly touch on the nature of intellectual property rights before we jump into the crux of it all. Intellectual property rights are what they said is it's rights that are granted for intellect created by the human mind, so property of the intellect. So all these creations are concepts and creations of the human mind, and they are territorial in nature, as I've already mentioned. And these rights are intangible. You can't see these rights, but the products they are do exist in a tangible form. So your patent will set out the disclosure of what the invention is, and the production of that product or that invention can be reduced into a material form. These rights do exist independently of their creator. But what's always very important is although these rights are intangible, you need to consider it as you would a tangible asset. So whether it's a house or a car, you know, it is an asset that is in existence and that is capable of being sold, which is your assignment to your third parties. It is capable of being given up as security, you know, if you are trying to secure a loan from a bank. So intellectual property is a very invaluable form, a very invaluable asset that should be exploited. And if you look at some of the more recent literature, the largest corporations today, if you think of Google, Facebook, Apple, a lot of their company value is based in their intellectual property. It's no longer focused on this hard industrial economy. You know, there is that shift to the fourth industrial revolution, or we're already in the fourth industrial revolution. But it just indicates the value of intellectual property today. So do yourself a favor and go do some research on the value of these companies and you know, where the value sits, and you'll find that 75% of some of these largest corporations have their value sitting in the intangible assets, your intellectual property rights, so all your patents, trademarks, and that. Okay. I mean, think of the Coca-Cola brand. How much value is held within that one trademark of Coca-Cola? And then, as I said, you know, apart from it being assignable, where you can transfer it from one person to another by agreement, there is commercial value to this and economic value. That doesn't mean that every patent is going to make you money. That's not the case, right? And that is something that you are ever dealing with inventors with, is you have to be upfront. You have to be honest with them and say, this doesn't give you a right to secure economic freedom. So you need to understand what is the need for a specific invention and how best to exploit it. Just because somebody wants to obtain a patent doesn't necessarily mean it's the best route or course of action, okay? Because it doesn't always ensure economic success. But when it does strike, it can secure a lot of economic value. And intellectual property, as you know, are all creatures of law. Then there is the debate of whether intellectual property rights are movable or immovable. And it was held in the oil well case that intellectual property rights are immovable. So if you do want to go read through that case, you're welcome to. It touched specifically on a trademark that was exported or assigned to a non-South African entity, and whether it was deemed immovable or movable. But in that case, Judge Harams held that it was an immovable property. I don't quite grasp that it is immovable. But they say because that right is territorial, it is in South Africa, you can't really export it. Okay, so what is a patent? Does anybody want to tell me what a patent is? What they think a patent is? Nobody. Come on, don't be shy, guys. What do you think a patent is? Anybody? I'm going to pick on names here. Let's see, Bianca.
Oh, I knew it. Okay, what I think a patent is, for example, it's something you invent, so it's something new, and then you get a monopoly for 20 years. So and then after 20 years, it's in the public domain. But yes, in your patent specification, you have to fully disclose. I've seen a patent specification and it's quite, yeah.
Okay, yeah, so that's quite spot on. So what you've touched on. So it is that right that is granted to you by the state. And that is why these rights are territorial, because it's a state that grants you that right for that monopoly. And that right is for you to exploit your invention. Okay, just remember that this right is a negative right. And the reason why it's a negative right is because it excludes other people from making or using or selling the invention itself. Okay, so it's a negative right because it excludes other people. And that right is granted to you, as you mentioned, for limited duration, which in South Africa is a 20-year period. So remember, the intellectual property rights are very anti-competitive. And the economies don't like anti-competitiveness. They want competition in the economy. And that's why a lot of the time these rights are granted for a limited monopoly, so that you can't continue to exploit it to eternity, but that the public can also at a later stage benefit from the invention themselves and exploit it themselves. So in their very nature, they are anti-competitive, but in return for that monopoly that is granted to you by the state, you need to disclose what the invention is. And you need to disclose it in such a way that whoever picks up that patent specification, but more particularly somebody that is skilled in that specific technology, in that art, that they are able to implement what it is that you've set out in that specification, so that they can go out and manufacture the invention or produce the invention, whatever it might be that's disclosed in there. So you have to fully disclose what that invention is in return for that monopoly. And as I said, that disclosure is what drives innovation, because at the time of grant, or depending on what stage in the prosecution the patent is at, that document becomes publicly available. So anybody can gain access to that document and further exploit it to see, how can I improve on what has been disclosed in this patent specification? So if you think back again to the Thomas Edison light bulb, looking at that light bulb, somebody would have looked at that patent document, seen, I can possibly improve on this in some way or another. perhaps the way it fits into the socket or not. So that's really the importance of the patent disclosure, is to drive that innovation and to take technology forward. Okay, I've touched on quite a few of these briefly. So what is the purpose of a patent? And the main one is that quid pro quo principle that exists in patent law, where in exchange for that monopoly, you are granted that time to exploit and to make your money, whether you're licensing the product, you're selling it yourself, but in exchange, you need to give that disclosure. So as we said, just to briefly recap, it encourages that improvement in technology by driving in innovation. It gives reward for improvements. It allows for that disclosure for others to obtain the disclosure for the improvements. And it also encourages the application of the invention in society because it will obviously enter the market and basically force the market into using that new technology. But it also encourages people to seek protection because there is this just reward given for a granted patent. And then it also acts as a deterrent against potential infringement, so that you do have your patent certificate and the rights granted to you, where you can show, hang on, you can't infringe my product, the rights exist with me. So there is that deterrent effect, and also gives you that remedy should somebody be infringing on your rights. Okay, so just in front of us is an illustration of what the letters patent document looks like, which is issued to the owner of the rights to the invention once it is granted in South Africa. And again, just to summarize, that a patent is an exclusive right granted for an invention, which is new, either a new method, a product or apparatus, a process, or use of a product that provides a new way of doing things or offers a new technical solution to a problem. Okay, so just a very brief definition of what a patent is. Are there any questions at this stage?
Hi, Marco.
Hi, sorry, who am I speaking to?
Spokazi.
Hi, yes, how can I help you, Spokazi?
There's a question in the chat box from Nai. Yeah.
Sorry, I don't have that open. Let's see. Okay, so Naveen, you've asked if section 25.1 forms part of the definition.
Hi, yes, Marco, I did.
Okay, so section 25.1, and we will get to section 25.1, but section 25.1 rather tells you what is the requirement for patentability. So it doesn't tell you what a patent is, but it alludes to what is protectable as a patent. And interestingly, the Patents Act doesn't give a clear definition of what an invention is either. If I just have a look at the Act briefly. So in the definitions of the Act, it says an invention means an invention for which a patent may be granted under Section 25. So very up in the air definition. It's quite open-ended. So not really a clear definition of what an invention is itself. But Section 25 does provide exclusions from patentability. So anything which doesn't form part of those exclusions is capable of patentability, provided it meets all the other requirements. But we will get onto that a little bit later on and delve really into it. So you should have a clear understanding of Section 25.1 before we leave today. Okay. Are there any other questions so far?
Hi, Marco.
Yes.
When you were speaking to the slide on the 1474, the first codification,
Yes.
you mentioned you requested that we just compare that with the requirements in the South African Patents Act, but I just missed the actual provision in the legislation.
Okay, so Look, it wasn't a specific provision, but most of the emphasis would be on Section 25(1) here from the Patents Act, where the requirement for patentability is that it has to be new. So you have that novelty requirement where it hasn't been disclosed before. And then also the requirement of utility. So the invention must be capable of being used in any form of industry or trade. But as I mentioned, this introduction into the history is purely just to hopefully whet your appetite and to see where it all stems from. But there won't be any question on this aspect itself in the exam. It's just very interesting to see that we haven't moved that far away from this first codification of patent law, specifically in terms of Section 25(1). Any other questions so far? Okay. So that's just the very quick introduction into patent law. Am I moving too fast? Is everybody able to follow with me? Okay, I'll take Kagiso and Kimberly's nods as a thumbs up. But please, as I mentioned, feel free to stop me at any stage if I am moving too quickly. There is a lot to cover, and I think we'll all be quite tired by the end of today, but we'll get there. So if we look at the international arrangements, so the instruments, the international instruments and treaties that govern patents and very broadly intellectual property, I think a lot of you would have some knowledge of these treaties already, which would have been covered by Dina, I think, if you haven't already, or if you have attended her lectures. And the first important one that relates to intellectual property is the Paris Convention for the Protection of Industrial Property. And I'm just briefly going to run through this because, again, I think most of you have some understanding of this already. But they provide for three objectives or three principles in the Paris Convention. That is the principle of priority rights, the principle of national treatment, and then the common rules, as it's referred to. So the principle of priority right is that if you file an application in one of the convention countries of the Paris Convention, that proprietor is given that right to claim that priority date of an application that was filed in a foreign country. So say that an inventor has filed a patent application for his invention in France, for instance, he's granted the right to priority in any of the countries that are part of the Paris Convention when he seeks to file a patent application across the world. And the same applies to trademarks and design rights. For patents, the priority period within which to file is a 12-month period. So if you filed your first application in France, within 12 months, you need to file your application in South Africa to have a valid patent right. Okay, so you have a 12-month period within which to file your application in most countries across the world that are party to the Paris Convention. Then the principle of national treatment, that just says that all those members that are part of the Paris Convention must afford the same protection to members of contracting states. So the same protection that they would afford to their own nationals should be granted to those who are members of the Paris Convention. And then just the common rules, which is aimed at harmonizing the laws in different contracting states. And the Paris Convention is administered by the World Intellectual Property Organization, and South Africa became a party to the convention in December 1947. So soon after World War II. Hi, Precious, you have a question?
Yes, Marco, I just want to ask, I don't know if I understood you correctly, ne?
Okay.
If there's a dispute maybe between two countries that are party to the Paris Convention, two countries. Which court will hear the dispute?
Look, so
Is there like an international court, or it will depend in whose jurisdiction the dispute is at?
okay, so the Paris Convention, what it aims to achieve is the harmonization of intellectual property laws. It doesn't necessarily regulate disputes between the contracting states. It just helps to streamline the process in which a national of a specific contracting country, so me as a South African, if I file an application in France, that I am afforded the same right. So it's not between disputes between the countries itself. It's just that those that are party to the Paris Convention, that there is a harmonization between those laws. What happens if those countries don't implement or abide by these objectives? I'm not entirely sure how that is regulated, but it will be in some form of international law as to how it is regulated. So not a very clear answer I can give you on that, Precious. But it doesn't regulate the disputes between the countries themselves.
All right, thank you.
Okay, if we then move on to the next important treaty, which is your TRIPS agreements, which is a trade-related aspects on intellectual property rights. And this treaty is regulated by the World Trade Organization, which South Africa has been a member of since 1995. But South Africa is also a member of GATT since 1948, and GATT is basically the present-day World Trade Organization. And again, a lot of similarities between the Paris Convention and TRIPS, where again it also establishes this international minimum standards for the protection and enforcement of intellectual property rights, and also the national treatment and most favored nation treatment. So to ensure that the best possible rights are afforded to applicants that make use of TRIPS. But the most important for patents will be your Paris Convention, particularly because of the principle of priority rights, and then also the Patent Cooperation Treaty, which is where most of my work is focused on in South Africa, because I'm at the end of the entire PCT process. So, as you all know, these rights are territorial in nature, but there are these treaties that do streamline the process and make it easier to obtain global intellectual property rights or global patent rights. And in particular for patents, that is your PCT agreement. And it basically provides for a unified filing system. So an inventor will file a patent application to WIPO, and they'll be granted a PCT, international application. And then at a later stage, they will then enter that application into South Africa. So for those that are in trademarks and have an understanding of the Madrid Protocol, it's quite analogous to the Madrid Protocol, where you file your international application, then later on you will enter the national phase where you seek to obtain protection in different countries. The benefit of the PCT is that you are given an international search report. And this will be very foreign to you all at this stage, but as we move through the workshop, you'll have a better understanding of it. But they conduct a search to see whether the invention which you're seeking protection for meets the requirements for patentability. So is the invention new? Is the invention inventive, and is it capable of being used in the trade or industry? So they'll conduct an international search, a global search, and issue the applicant with a report. And based on that, the owner of that invention is able to assess whether they can overcome any objections raised in the search report. So can they overcome this novelty objection, for instance? So if it is discovered that there is an invention alike, that they are able to overcome that, and whether it is actually worthwhile seeking patent protection across the world. So the Paris Convention also comes into play here, because if you file your patent application, say in South Africa, you again have a 12-month period within which to file your PCT application. And then within 31 or 30 months, depending on the country, you then file the national phase application. So there's a much longer time frame within which your rights are actually granted. So if you're filing a convention application via the Paris Convention, you have a 12-month period within which to file your application. But if you file via the PCT, it's extended to a 30 or 31-month period. So it gives the owner of that invention a lot more time, whether they wish to seek funding for the invention, to obtain funds, to protect the invention more globally, to see if there is a market for it, to conduct market research, if there are any improvements that can be made, and then also obviously to await the search report to overcome any of those objections that may be raised at the international phase. But we'll touch on this a little bit more as we move on. But just so you know, South Africa acceded to the PCT in 1998. It was only implemented on the 16th of March in 1999. So from March 1999, we could file PCT applications, and we could also file national phase applications. What the benefit of this is because of the streamlined process, it allows for a more global spread of the technology. So if you're seeking your protection for your invention, you're basically transferring that technology into whichever countries you nationalize the patent application in. So it has that benefit on transferring technology to various countries across the world. At present, there are 153 countries that are member states of the PCT, so quite a large number of countries that are party to PCT. If we have a brief look at the PCT on the slide in front of you. So the inventor would have devised the invention. They will then file an application in their local country, or they might file it directly with the PCT through one of their receiving offices. So if it's South Africa, South African Patent Office would be a receiving office. You then designate who must conduct the search. So whether it's the European Patent Office, whether it's the American Patent Office, they will then conduct the search. They will issue you with the search report. They publish it on Patent Scope, which is where you're able to access all the data of this application. And then, your reports are issued, you're able to amend the applications. But as I said, we will go on this in a bit more detail. So I know you're probably all feeling very lost at this stage. But once all of this is done, you will then enter into your national patent offices. Okay, but we will look at the slide again a bit later on. Are there any questions at this stage?
Marco?
Hi, yes.
It's Kangwero here.
Yes.
I just wanted to find out, are you expected to bring a full disclosure when you have to file for PCT?
Yes, you are.
And so it's still confidential?
It is confidential at the filing stage, but you'll see that it is published generally within 18 months from the priority date. So quite soon after filing the application, it is published on Patent Scope over here, where it becomes a public document.
Okay, thank you.
Okay, no problem. Okay, I think it's now 10 o'clock. If you don't mind, if we can break for 15 minutes, and then we'll be resuming or reconvening at 10:15, just so I could clear my throat a little bit and to give you all a short break before we move on to the real in-depth crux and the nature of patent law. Okay, so I'll see you all in 15 minutes then. Try not to be late and then we'll get going. Thanks. Welcome back, everybody. I think we can commence our workshop this morning. Thank you, Kimberly. Okay, just admitting a few attendees, then we can move on. Are there any questions that anyone might have from the introduction we've just covered that they would like me to recap or emphasize? Lufuno.
Hi, Mark. How are you?
Hi, nice to hear from you.
I'm good, thanks. Marco, I think there's some questions posted on the chat. I think.
Sorry, the problem is the chat isn't showing on my side because I have the participants view.
Okay.
But I'll move over to the chat and then we can quickly work through that.
Thanks.
Thanks, Lufuno.
Okay.
Okay, so Lufuno was asked when filing the PCT application, the invention is published after 18 months, whereas for the filing in South Africa, the patent is published when the patent is granted. Okay, so I see you refer to PatentScope. So PatentScope is just the website that WIPO uses to actually publish the specification. And for the PCT application, that international application is generally published at the 18 month from the priority date. Whereas for South Africa, it depends on the route that is followed, but we will touch on when the application is published in South Africa. It all depends on what route was followed. So if it's a national phase application that comes from the PCT, then obviously it's already open to public inspection because it was published at PatentScope. But if it is a South African application from a South African priority application, then it does only become open to public inspection once the patent is granted. So on the date of grant, it becomes published. If it is, however, from a foreign convention application, so if it's a complete application where they didn't go the PCT route, but they filed a Paris Convention application in South Africa, then it becomes open to public inspection at 18 months. So similar as it does for PCT. So it all depends on the various routes that are taken, but we will touch on that briefly. And then Nomkosi Peter, you asked what are the common rules under the Paris Convention. So what is meant by the common rules is basically just that harmonization between these countries. And that is what's really great about working in intellectual property law, is that the laws are very standardized, they're very harmonized across the world. So there's no difficulty when, for instance, in my profession, where I am dealing with foreign associates, foreign applicants, understanding the various rules and requirements when it comes to patent law, because those rules are all are generally standardized. There are obviously caveats and differences between the national laws, but the common rules that I'm referring to is basically just that harmonization of the rules in terms of the TRIPS and Paris Convention. Just to correct myself, earlier I mentioned that about 75% of the large companies have their value sitting in their intangible assets. It's actually much higher than that. So even better news for those that are exploiting intellectual property. So if you have a look at the S&P 500, out of the top companies, of the top 10 companies on the S&P 500, which includes Apple, Microsoft, Amazon, Alphabet. More than 84% of those combined assets sit in intangible assets, which is your intellectual property. So far more than 75% that I previously thought. It's actually sitting at 84%. So just to show the value of intellectual property and why it is so important to protect these rights, because you might be sitting on a gold mine, your client might be sitting on a gold mine. Okay, so that was basically just the introduction that we had earlier this morning, but now we're going to delve into the real theoretical part of the work. Kimberly, can you just nod? Can you still see my presentation up that says patentability? Thank you. Okay, so first of all, we're going to delve into the patentability requirements. And this section is probably the most important section of the Patents Act, and probably the most important for the examination as well. I can probably guarantee a 25% of the exam component will be made up of work that comes from Section 25. So I can't emphasize enough the importance of Section 25, and that's the entire Section 25, not just Section 25(1). So you really have to have a very good understanding and grasp of what Section 25(1) entails, because it is the basis of patentability in South Africa, and what is patentable, what is not patentable, and what the requirements are in terms of patentability in South Africa. So please, I implore you to really focus on this section. As I said, about 25+% of the exam will focus on patentability, particularly in terms of Section 25. Just before we proceed as well, one thing that's very important is that a lot of the sections in the Act do seem quite long-worded and long-winded, but it is very important to look specifically at the words that are used in the Act. As patent attorneys, in particular, words are vitally important, especially if you are drafting patent specifications and claims. That's what the court will look to when interpreting what the scope of protection is of your invention, is those words. And similarly, the words in the Act are very important because they do have very specific meanings as well. So just as an example, where the Act refers to fair basis and fairly associated, that's very different. Although it might sound the same and you might interpret it the same, but there is a different meaning as to fair basis and a fair association. Just as one example, but these are things to look out for and to actually understand the meanings of the words that are used in the Act. But that's just a general comment. So if we turn to Section 25(1), and the basic requirements of obtaining a patent. So Section 25(1) says that a patent may, subject to the provisions of this section, be granted for any new invention which involves an inventive step and which is capable of being used or applied in trade or industry, agriculture. So Section 25(1) really at the heart of patent law and what the requirements are for obtaining a patent. So it says a patent may be granted for any new invention, but as we discussed, the Act is quite wishy-washy in terms of what an invention is, in terms of the definition, but it does provide us with exclusions. So the first requirement is that the invention must be an invention by definition. And what I mean by that is that anything which does not form part of any of the exclusions in terms of Section 25(2) or any of the other sections in Section 25 is capable of being an invention or being considered an invention. So firstly, there must be an invention. Secondly, the invention must be new. Okay, so there mustn't have been any existence of this invention previously. Nothing like that must have existed before. Now, I don't want you to think of this novelty requirement as being a groundbreaking standard of novelty. And what I mean by that is that any improvement to an already existing invention is also new. It doesn't need to be that that the cell phone needs to be new, okay? Any improvement on the technology, so long as that improvement hasn't existed before, is still capable of being, or capable of meeting the novelty requirement. Okay, so how the courts would interpret novelty, we'll look at that, but a lot of inventions have the same features, okay? So if there's basically a shopping list, it must have, let me consider a scissor, okay? So if we look at the scissor briefly, okay? It will have the handles, it will have a set of blades capable of cutting paper, okay? So that would be your claim for your scissor, very layman's terms. But then you might have a scissor. I don't know if you've seen one of those scissors that's got multiple blades that are used for cutting herbs, okay? So although the concept is the same, there is an improvement on an existing technology. Okay, so because of that additional integer that hasn't existed before, it will meet the requirements of novelty and will be considered new. So it doesn't need to be groundbreaking new. As long as there is an improvement of something that hasn't existed before, you might still fall within the requirements of it meeting novelty. Okay, but we will touch on each of these a little bit later on so that you can have a better understanding of it all. The next requirement is then that the invention must involve an inventive step, and that is that it mustn't be obvious to somebody skilled in the art. So how does that invention go above and beyond what's already known? How does it move forward? How does the technology move forward? And that inventive step doesn't necessarily need to be a step forward. It can be a step to the side as well. And what I mean by that is that there might be a certain way of manufacturing a pharmaceutical composition. Okay, so that's the technology that's known. But there might be a different way of reaching to that same step or that same product, just done in a different way. And that would probably be considered a more of a sideward step instead of a step forward, because you're still obtaining the same result. It's just the way in which you get there, which is different. So there must be this inventive step as to actually moving that technology forward and being inventive. I mean, that's what an invention is. It's supposed to be inventive. And that's where this requirement of the inventive step comes in. So the novelty requirement is very objective. As I said, when a court assesses novelty, they'll look at what is available in the public domain and draw up a shopping list and see, are all these integers there or not? If all the integers are there in a prior document or article, whatever it may be, where there's been a disclosure, then there won't be novelty in the invention. But if there is something on that shopping list that is new, then by comparison of what is already known in the public domain and the present day invention, you will have novelty. So when assessing novelty, it is very objective. Okay, it's basically a comparison of A and B. Inventive step is very subjective, on the other hand. When the courts assess inventiveness, the parties will generally bring in expert witnesses, and the court will consider what the expert witnesses have said. And the expert witness will be somebody that is a person that is skilled in that art, somebody that has an understanding of that technology, and they will give their opinion as to whether the invention can be considered something obvious or not. And as I said, the courts, it's not a binding opinion by the expert witness. It's merely to state an opinion of the expert witness, and the court can consider it. They do not have to, they may. An example of this, of a very recent case that Spur and Fisher was involved with, the judgment was only given about a month ago, was on the mines, they used to use LiDAR to actually map out the, let's say the terrain. And this device that they used would be attached to a trailer, okay? But then somebody came up with an invention to attach this device onto the back of a 4x4, for instance. And the question arose, was it actually inventive by having this LiDAR device sitting on a trailer previously and now having it attached to the actual vehicle itself, you know, forming part of the vehicle? Is that inventive or not? You know, and that's what the court would need to consider in terms of inventiveness. And I think the court found that it wasn't really inventive. Okay, then the last requirement is that the invention must be capable of being used or applied. It must have some utilitarian function or purpose in either trade or industry or agriculture. We're not going to really touch on this provision because I don't think there's ever been an objection where an invention isn't capable of being used or applied in some way or another in any form of industry or agriculture or trade. Okay, so as we said, in order for an invention to be patentable, it needs to meet certain intrinsic and extrinsic requirements, and the most important of these are in section 25.1, as we said. Again, this is just a rehash of what I've already touched on, setting out section 25.1 briefly for us, saying that the invention must be patentable per se. As I said, the Act does not necessarily define what an invention is, but only what is not. And then anything which forms part of this list is then capable of being an invention. Sorry, what doesn't form part of the exclusions is an invention. Okay, so if we turn to what the extrinsic requirements are of patentability. So if we look at section 25.2, this is part of the Act that tells us what is excluded from patentability. So anything which consists of a discovery, a scientific theory, mathematical method, literary, dramatic, musical, artistic work, or any aesthetic creation, a scheme, rule, method of performing a mental act, playing a game, or doing business, a program for a computer, or the presentation of information shall not be an invention for the purposes of the Act. So section 25.2 very nicely tells us what is not capable of being considered an invention and therefore capable of being protected as a patent. And if we just look at each one of these very briefly, so a discovery is something which nature has created. It's always existed. Just because you have discovered it, you haven't actually invented. Nature has created this, and that which nature creates, you cannot claim as your own, basically. So it is just something that has been found, which has already existed previously, and therefore is not capable of patentability. So if we look at a scientific theory as well, it's just an explanation in a scientific manner to explain some part of the natural world. And an example there is Newton's laws of motion or thermodynamics, just some of the scientific theories. Then mathematical methods. So again, as with scientific theories, a mathematical method is a description or system that is used to, again, explain something of the natural world in a mathematical way. And such an example would be the theorem of Pythagoras. So again, not something that is capable of patentability. Then if we look at your literary, dramatical, music, artistic works, or anything of aesthetic creation, you can see that this falls solely within the ambit of copyright law and then also in design law. So again, anything which forms in this category is not capable of being an invention for the purposes of the Act. Then schemes, rules, method of doing businesses, these are considered to be essentially mental steps or methods of applying one's mind. So again, not something that is actually a creation, and again, not capable of being protected. And then such an example of could be the rules of the card game, Cards Against Humanity, or the rules for blackjack, or rules for poker. Interestingly, computer programs, again, fall solely within the definition of copyright, and one of the works that are defined in the Copyrights Act. But the Copyrights Act only provides for the protection of the source code. So the actual operation of a program falls within copyright. A very interesting one, computer programs, because as you can imagine, the use of digital technology, the amount of new applications that are being developed for cell phone use or computer use, a lot of people do want to protect their cell phone applications or computer programs that they've devised. And it does happen where people seek patent protection for the applications that they have devised, and they have been successful in obtaining this. And you'll see that one of the articles that I have sent through to you looks specifically at the patentability of computer programs. So please do have a look at that article for a more detailed analysis of computer programs and their patentability. But what the courts have basically held, so there's been no consideration by the South African courts in terms of computer programs, but the European courts, which South African courts often turn to when interpreting statute, is that provided there's some technical effect granted by this computer program in terms of an application, it is possibly capable of being protected as a patent. So as long as the computer program isn't applied as such, as you'll see from section 25.3, as exactly as it stands, just that source code. But there is some added benefit of it where it is interlinked with the hardware and the software, the other software in whatever device it's being used, and it provides a technical result and fulfills a purpose where there is a gap, then it is likely to be patentable. So it is very likely if South African courts have to consider this, that they will follow the European approach and find that the patent is valid, provided that it has a technical effect. And then again, the presentation of information. This is again works which are considered in terms of the Copyright Act and excluded from patentability. So if we touch again, as I mentioned on 25.3, it says that the provisions of such subsection 2 shall prevent only to the extent to which a patent or an application for a patent relates to that thing as such, anything from being treated as an invention. So what this caveat in terms of section 25.3 does is it provides for a very narrow interpretation of section 25.2, which is these exclusions from patentability. So these exclusions need to be interpreted narrowly. And that's why we say when it comes to computer programs, the exclusion probably refers only to the source code, which is protectable in terms of the Copyright Act. Again, even just not with computer programs, there's no case law in terms of the interpretation of section 25.2 or 25.3. But as I said, the Boards of the Appeal of the European Patent Office mentioned that there must be some technical effect if a patent describes subject matter which is excluded from patentability. So provided there is a technical result, then it may be possible to obtain a valid patent for that invention. Are there any questions regarding section 25.2 so far? Okay. Let me just double check the chat group. Okay, nothing so far. Okay, if we then look at other unpatentable inventions, Section 25(4) says that a patent shall not be granted for an invention, the publication or exploitation of which would generally be expected to encourage offensive or immoral behavior. So a patent shall not be granted where the publication or exploitation of that invention would encourage offensive or immoral behavior. I had, and I'm allowed to disclose this because it is publicly available, but I was dealing with an invention yesterday where it was for a vehicle that basically, it almost looks like a 4x4, but a smaller version of a tank, an army tank, where it also has a machine gun basically sticking out the top of it. And that made me think about, you know, would it fall foul of these provisions? Because would it encourage offensive behavior perhaps, or would it be against the laws of the country? So just a person does come across these types of invention. Another one might be, as an example, possibly a date rape drug, you know, where a drug is specifically used for illicit purposes. Is it capable of being patented? And it would likely fall foul of the provisions of Section 25(4)(a), where it would encourage offensive or immoral behavior. But again, a very subjective interpretation and test when considering that. Okay, very importantly then, as was Section 25(4)(b), that says a patent shall not be granted for any variety of animal or plant or any essentially biological process for the production of animals or plants, not being a microbiological process or the product of such a process. So for any of those that are in the biotech fields or genetic engineering or molecular engineering, this is a very important provision, because as you can see here that any new variety of plant or animal is not capable of being patented unless it is a microbiological process. So microbiological process, for instance, would be the development of an antibiotic, which is a microbiological process, and that would then not fall foul of these provisions. But when it comes to genetic engineering, you have to be very careful not to fall foul of these provisions in terms of Section 25(4). And also, if we're looking at a variety of plant, that falls within the sui generis legislation of plant breeders' rights, where those rights are granted for any new variety or even a discovery of a plant in terms of the Plant Breeders' Rights Act. So that's why the exclusion for plants is provided for in terms of Section 25(4), because as with copyright law for computer programs, there is separate legislation that deals specifically with any new variety of plants. And there's a lot of that goes on. I mean, especially if you walk into a Woolworths, for instance, and you look at the fruit that they have available, you know, they've got cotton candy grapes and those nachi fruit that so the Clement Golds, those have all been enhanced to seek specific traits that they wish to exploit. So the sweetness of those cotton candy grapes, you know, there's been some crossbreeding or genetic modification there, and that will form under the Plant Breeders' Rights Act, where protection can be sought for that. But when it comes to a variety of an animal, so no Frankenstein type of stuff is capable of being patented. Yeah. Okay. Just something that is very important to note is Regulation 28A of the patent regulations, which relates to the Budapest Treaty and depositing microorganisms. So in your patent specification, you have to clearly disclose your invention. And if your invention does involve a microorganism, then you have to make that microorganism available to the public. And how that is done is in terms of the Budapest Treaty, there are deposit banks where the inventor or the owner of that invention needs to provide a sample where they can preserve that organism, whether it's by cryopreservation, they'll preserve the microorganism, and they will be issued with an accession number. And that accession number needs to be made available in the patent specification. And you'll often find that we lodge the documents pertaining to that microbiological deposit. We lodge that with the patent office as well when we file these microorganisms. And you do come across quite a few of these inventions, not necessarily in South Africa, but ones that do stem from abroad. So that microorganism will be deposited, say in the Netherlands, for instance, and they issue you with a specific number for anyone to be able to find that microorganism. Okay, if we then move on to section 36, which also then looks at other unpatentable inventions. These are not unpatentable in a clear-cut way, but it grants the Registrar of Patents the discretion to refuse patents where they may be contrary to well-established natural laws. And an example of that is a perpetual motion machine. So a perpetual motion machine, and trust me, in practice, you'll have a lot of inventors that will come to you that say that they have found a way to infinitely generate energy. And it is just against the natural laws of nature. It's impossible to do that. There are a lot of factors that don't allow for that. So if it is an invention which is contrary to natural laws, then the registrar may refuse that patent from granting. Again, the invention which would be generally expected to encourage offensive or immoral behavior, which is basically a repetition of section 25(4), where the registrar is granted with discretion. I don't know why it is actually repeated in the Act, because on the one hand, at section 25(4), it says a patent shall not be granted, but again in section 36 it's contradictory because it grants the registrar the subjectivity to refuse it. And then an invention which may be used in any manner which is contrary to law. So if you consider your warfare type of inventions that is contrary to law, it will also again be to the discretion of the registrar to refuse that application for a patent. Something to have a look at, which I also deal with quite a bit, is the patenting of nuclear inventions. So any technology which relates to nuclear inventions is subject to the Nuclear Energy Act provisions as well. So if there is an invention that relates to a nuclear type of technology, the applicant needs to inform the Minister of Mineral Resources and Energy that they are applying for an application that relates to nuclear technology. And the Minister of Mineral Resources and Energy, they needs to work through that patent specification, and he needs to inform the registrar whether it is permissible for the patent to be granted in South Africa or whether it's not. Okay, so just something to keep in mind as well, if your invention relates to nuclear technology, that there are these further steps that need to be taken in securing your patent rights in South Africa. Any questions on this slide so far?
Yeah, Malcolm.
Hi, yes.
Okay, it's come well. I just wanted to, I'm hearing my voice.
Okay, let me.
Okay, I just wanted to find out, when you start, you said section 25, the whole of it is very critical for this module. However, we touched only 4 subsections, and I noticed that there is at least 12 subsections. So how do we go about that?
Thanks, Onatile. So we're still going to get to the rest of the sections. You'll just see that the slides that I've put in the presentation are very well grouped together. So you'll see that section 25 does jump around a little bit between the different aspects of section 25. So I've just grouped together section 25.2, which is unpatentable inventions, and how that section should be interpreted in terms of section 25.3, and then again section 25.4, looking at what else is unpatentable. So we are going to touch on all the sections. It's just the manner in which I've grouped it so that it forms part of a certain topic that we're discussing.
Thanks, Mark.
Okay, no problem.
Hi, Marco. I just have a question regarding this 25.4a and 36, the second bullet. Have these provisions ever been challenged, because they seem very open-ended and super subjective? You're on mute, sorry.
Thank you. I'm mute because otherwise there's an echo. As far as I know, there's never been any interpretation of these sections by the South African courts, and I'm not aware of foreign judgments relating to similar provisions in foreign jurisdictions. But you're very correct to say that they are extremely subjective and very much open to interpretation. And that's why, unfortunately, we can't really delve into much more on what these provisions say, because it is so subjective.
Yeah.
What might be immoral for one person might not be for somebody else.
Exactly. Yeah.
Unfortunately, it'd be great if we all had the same morals, but that's just not how the world works. So, and it also doesn't state, against which criteria it should be measured. I'm assuming in terms of interpretation of statutes, it would be in the public interest. So, how would the public generally assume it to be immoral or offensive? So you're very right, very subjective and a difficult one to answer.
Okay.
Thanks.
Thank you.
No problem. Kimberly?
Hi, I was just wondering with the Budapest Treaty, the depositing, does it have to be in South Africa? It sounded like you said the Netherlands, so is it just you have to have it deposited somewhere in the world, or
Okay.
yeah.
So it doesn't really matter where it is deposited, provided that whoever is reading that patent specification does have the available information before them to actually obtain that sample. So it doesn't need to be in South Africa. And you must remember that a lot of the applications that enter into South Africa are from abroad. So they stem with their origins in Europe or Asia or Americas before they come to South Africa. And that deposit would have already been made elsewhere in the world. Okay.
Marco,
Hi.
Nomkosi here. So it need only be deposited once, and it is applicable for filing in any jurisdiction.
Yes. So what happens is that the body that receives this organism will then issue the applicant with a certificate stating when the deposit was made, where the deposit is housed, and then also with an accession number. So they'll issue that certificate, and that is generally filed with the applications, but it may be contained in the specification as well. So only one deposit of it is fine. Okay, if we then move on to another form of unpatentable inventions, and as you can see, I've tried to group everything together that relates to the same topic, and that's why we're jumping around in terms of section 25, but it's just so that we deal with one topic at a given time. But in terms of section 25, we have our method of treatments. And section 25.11 says that an invention of a method of treatment of the human or animal body by surgery or therapy or of diagnosis, practice on the human or animal body shall be deemed not to be capable of being used or applied in trade or industry or agriculture. So you can see why I said that the Act often has this very long worded way of saying something, but it basically says a method of treatment of the animal or human by either one of those options is not patentable. And why this is very important is because, as we mentioned, the laws across the world are very different. So in America, for instance, a method of treating a patient for an illness is patentable, whereas in South Africa, it is not patentable. And the reason for this is because you can imagine if a surgeon has to perform an emergency operation on a patient, and this method of performing the surgery is patented, that could potentially lead to the loss of life of that human. You know, it sounds very unethical to have this patentability against something that could save a life. And that is why this provision is there, is to allow you know, those in the medical profession or even veterinarian profession to actually perform their duties and what they are you know, bound by in terms of their oath and morally bound to do in their profession. But as I said, in America, America always goes one way and the rest of the world another way. But in America, for instance, they are allowed to patent a method of treatment for an animal or human. There are ways of overcoming this and still seeking some form of protection, because remember, it may happen that a patent is filed in America and they wish to seek protection in South Africa as well. So that specification will be filed in the South African Patent Office, but you'll be sitting with claims in the patent specification that have these method of treatment type claims. So before it proceeds to grant, the patent attorney has to look at those claims and advise the client to say, look, your claims are unpatentable in South Africa, and we suggest correcting this in the options that are available to the applicants. Kagiso, you have a question for us?
Yes, I just wanted to ask, so I see that in the medical field, there's a move with surgical operations where they start using like more mechanical style. Would the way that those machines work be patentable, as opposed to like the actual treatment?
Okay, so there's two things that you need to consider there. Is the machine itself a new machine? Because if the machine itself is new, then the machine can be patentable, provided it meets all the requirements. But the method in which it is used would not be patentable. So if that machine is used in surgery, for instance, then you won't be able to claim that patent. But for the product itself, because you know any professional can then or has the option to purchase that product and to use it in their practice. So you see there's two aspects to it. So for the machine itself, there is patentability there, but not in the method in which it is used. Okay. But this is an extremely important provision, and I want you all to just put this as an NB in your notes as well, because there is likely to be a question on method of treatments as well. And again, these words are very specific, so it has to be the method of treatment of the human or animal body, and that method of treatment can either be by way of surgery or therapy or of diagnosis. And you know, they each have their own meaning and definition. You know, so often a claim as well will refer to obtaining a sample from a patient, but all the work is done on that sample. So let's say you're taking a biopsy of a tumor. You know, the method of obtaining that biopsy would probably be considered a method of diagnosis because you're obtaining something from the human body, even though the rest of the work is done in a test tube. So in that instance, it would probably be advisable to remove that claim where you are obtaining the sample from the patient. Okay. But to ensure that you refer to the test in a test tube in vivo or vitro, sorry. Okay, so just a very, very important section to note. Okay, but as with the machine example, Kagiso, the compounds and compositions that are used in these methods of treatments are, however, patentable. Okay, and this applies to both first medical use and second medical use, and I'm going to touch on that now. So, although the method itself is unpatentable, the pharmaceutical, for instance, is capable of patentability. And again, this refers to both the first and second medical use of a known compound. So the first use of a compound would be where somebody has developed salicylic acid. Okay, and salicylic acid is your aspirin, okay, which was developed for the treatment of headaches or migraines. This is just a hypothetical situation here. I'm not too sure of the facts, but let's use that as the example. Okay, that was the first use of that compound that was ever developed. But it was later on discovered that the salicylic acid is also used as an anticoagulation compound. So it's a blood thinner, which is helpful for those that suffer with blood clotting, for instance, to thin the blood. So you can see the use of that compound is a new use. Although that compound has already existed, the use of that compound is new. And because that use is new, it is still capable of being protected. But it's for the use of the compound, not for the compound itself. So if you have a look, I heard somebody's microphone turn on. Was there a question? No. Okay, but there is case law on this, and a very important case, which is your Elan transdermal versus Ciba-Geigy. And in this case, the court held that if there is a first medical use of a compound, that compound needs to be claimed in what is known as the for-use type claim format. Sorry, this might bore those that aren't in the patent practice, but where that compound is for first medical use, you have to use the for-use type format, which is that a compound X, so your salicylic acid, for use in the treatment of the disease in a patient. Okay, so you can see that your claim is directed towards the compound, okay, which is being used for the treatment of whatever disease it might be. But if there is a second medical use, you are still able to obtain patentability for that use. And in that case, you need to follow the Swiss type claim format, where your claim is drafted to the use of that compound, which is the same one as above here, but in the manufacture of a medicament, so of another pharmaceutical compound to treat a different disease. Okay, so just very important provisions to note. So if it's a first use, you have to follow the for-use type claim format. If it's a second medical use, then it must be the Swiss type form. The European Patent Office has moved away from this, but this is still part of the South African law, because there is precedent for this in terms of the Elan transdermal case. And I mean, this happens often where a pharmaceutical is developed for a specific purpose, but it's later then found out that it has benefits for other forms of diseases or other forms of treating a patient for something else. Hi, Rabone, you have a question?
Hi, yes, Marco.
Yes.
I just wanted to ask, So then is the second medicinal use, the second medical use, not a discovery? Or does discovery only relate to something created by nature?
Yeah, so discovery only refers to something that's created by nature. And it is a very good point to make, because it can be that, it's discovered that it's treating a different type of disease, but it might be that they intentionally looked for other uses of that compound as well. So it might not be a discovery per se, but in terms of the exclusions, remember, it needs to be narrowly interpreted. So that exclusion of the discovery is what's being created by nature. Okay, so if we then just go on to the next slide, these are just some of the reasons and examples again of the first medical use. So as I mentioned, the drug might be developed for a particular purpose, and then later research finds that it is beneficial for another therapeutic area or field where it may be used as a treatment or therapeutic agent. Also, it could be that there has been development for this drug for a specific purpose, but it didn't succeed in what they were aiming to achieve. And however, there was some other form of treatment where it was actually therapeutic in nature. And then also sometimes where a compound for non-medical use is found effective for medical use. And a prime example of that would be marijuana. People use it as a recreational drug, but instead it does have other medical uses. Okay. And then just again, an example of what the claim format should look like for first medical use and the second medical use of a known compound that you can have a look at there. While we're on the topic of pharmaceuticals and drugs, I mean, there's obviously, and I'm going to open the floor to you all as well, because it's nice to have a bit of a debate about this. But, we find the world finds itself in this crisis of the COVID pandemic and the development of vaccines. And along with that, there's a lot of development, a lot of expenditure of money that's taking place in the development of that. And, South Africa and India are two of the countries that are approaching the world governing bodies to do away with patent rights for these vaccines. What are your views on this? And please feel free to give your opinion, because I think it's a very interesting topic. And I'm sure this is something that will also come up in the exam. So anybody, do you have an opinion on whether these vaccines should be patented or not? Wasim, you have your hand raised. Go on. Surely somebody should have an opinion. Hi, Nomkosi.
Hello. Hi.
Yes.
I'm.
Hi. Yes, go for it. What do you think?
Look, from what I understand, from the other lectures we've had as well, is that our law states that if they find that there's a need or a greater good, apparently, we are allowed, or our government is allowed to make that patent available for the greater good, I would suppose. And I think in the current situation that we're in, or that we find ourselves in, that would be the precedent to go with, considering the global scale that the virus has hit us with.
Yeah. Okay.
So I think that it would obviously benefit mankind. And look, it's not like the companies aren't making money with the vaccine in any case.
Yeah.
It's just, yeah. I suppose there should be a balance as well, so that there'd be an incentive for them to actually look for a vaccine instead of them hurting their pockets with the R&D that they're gonna have to go through.
Yes, you see, it's a very tricky balance to strike, because obviously there's a lot of resources placed on the development of these vaccines, and not just these vaccines, but also any pharmaceutical.
Yeah. And it's quite pricey as well.
It's extremely costly, and what the research shows is that for a drug that hits the market, where there is a patent on that drug, that developer of that drug, the owner of those patent rights, only tend to see a profit towards the 17th year of the life of that patent, between the 16th and 17th year of the life of that patent. So in all that other time, they're only recovering the costs that they've expended on developing that drug and getting the market approval and doing all the marketing and hitting the market. So there's a very limited period within which the pharmaceutical companies actually make some form of profit, and that's generally only from the 16th and 17th year where they start seeing profits. So it is a very difficult balance to strike. But you also mentioned that the vaccine is being sold at a not-for-profit or on a not-for-profit basis, but that's also only for so long as the pandemic is considered around. Yes.
Yeah.
But yeah, it's a very hot topic and a very interesting topic, I think. But yes, thanks for your comments. Nomkosi, I see you also have your hand raised for us.
Yes, Marco, I just wanted to say, I think the whole COVID vaccine situation almost takes us back.
Nomkosi, I think we've lost you there. Unfortunately, I can't hear you.
Ensuring that the IP system isn't used at the cost of public good, and ensuring that access is not
Nomkosi,
prohibited.
Just to interrupt you, you broke away for a large part of what you were saying. Would you mind repeating what you said?
Can you hear me now?
I can hear you now, yes.
No, I was saying, in short, I was just saying how the whole COVID vaccine situation reminds me of the discussion at the time of at the peak of the HIV pandemic around the access to therapeutics, and how the compulsory license issues under the TRIPS agreement and the various national patent laws played itself out, but also how the civil society movements were instrumental in ensuring that the IP system was not abused to limit access to therapeutics that were life-saving at the expense of profits by these huge pharmaceutical companies. So it will be interesting to see how the situation is, the whole issue is concluded. But I think for me, and having applied the similar issues in relation to climate change and mitigation-related technologies, this is going to be a case study that's going to be with us for a long while to come.
Yeah, look, you make very good points there. Speaking of the public interest and their participation in it as well, if you think of the Treatment Action Campaign that were at the fore of the HIV crisis that South Africa was faced with, they had a huge role to play in it. But the problem is, as well, as the previous guest spoke earlier, there has to be an incentive for these pharmaceutical manufacturers to actually develop the drugs and to expend their resources on it. But sadly, there are provisions, as has been mentioned by both of you, in terms of the Patents Act and in terms of TRIPS, for the patent rights to be done away with. In terms of the Patents Act, those rights can only be done away with where there is an agreement between the parties to actually do so. But then there's also the reliance on compulsory licensing, and which, might I add, South Africa has never granted a compulsory license before. So these provisions have never really been exploited. And even in terms of TRIPS, TRIPS also allows the countries to do away with the patent rights where there is a crisis, and I mean, COVID is a prime example of this. But and not to cast shade on the government, but they again haven't taken steps to legislated or to implement those provisions of TRIPS into South African law. So they fall foul there again, not being able to utilize that until they actually take those steps. So, you know, there's a lot of furor in the media, in the public, and in government, but there are these routes and channels for them to follow, but it doesn't seem as though they ever do, sadly. But that's just, again, my personal opinion. Lufuno, any questions from you? I see your hand is raised.
No, Mark, I was just thinking. Can you hear me?
Yes, I can hear you.
Okay, I was just thinking loud there because in terms of the IPR Act, we do have something like walk-in rights, but I know it's more on the national phase. So can't we have something like that internationally? Because I think just to say that we don't have to protect, to protect the innovations that might come out of for the medicinal of the treatment, it might discourage the innovation somehow. So can't we have something like walk-in rights? I don't know. What's your intake on that? I mean, international, something like that.
Look, I mean, TRIPS, and I can't recall the exact provisions, but TRIPS does allow for something like that, for a type of walk-in right in the time of crisis, as we are faced with now. So it's just up to government to actually, you know, in terms of international laws, the international law can't be applied until it's nationalized. So they actually need to incorporate it into South African law. Kagiso?
I think with something where there's an immediate need, the incentive kind of needs to be a little bit more creative. So I understand that monetary value and like the payout that you'd receive from the vaccines is obviously the number one, because everyone wants money. But I think that if companies start to think about it in a different perspective, for example, the free marketing that they can get if they come up with a vaccine, and how that could affect their sales for other products in the coming years. I think we just need to kind of get creative about what the incentive actually is to create the vaccine. I don't think that it only has to be a financial incentive. There could be other ways that companies could benefit from creating a vaccine.
Yeah, it's a very important point to make. And, you know, they can also consider free licensing, for example, between the global manufacturing or pharmaceutical developers, you know, where they can consider patent pooling, you know, which is also an option to reduce costs, where you know, one manufacturer might focus on a specific area of technology or have developed a specific component and allow that into a patent pool, allowing basically as in copyright, a Creative Commons license, where they have access to what is in that patent pool. So that's also something that I think should be considered. And it's the same with green technologies as well, you know, in reducing the effect of global warming. I think next we had Bianca. Your hand was raised.
I'd just like to say that these companies are actually making a lot of money. Well, yeah, I also thought it was just, but like Pfizer already made $15 billion from COVID-19 vaccine sales. And that was already in the news on the 2nd of February 2021.
Yeah. Okay.
So not as if these companies aren't making any money.
Yeah. Look, it's probably because of the magnitude of it, and that it's the whole world that needs these vaccines, that there is some kind of profit that they are making. But yeah, thanks for bringing my attention to that. I'll definitely look into that, read up on it. Next we had Ontatile. Sorry if I mangled your name.
No, it's correct. I just want to agree with Kagiso and Bianca. I think it's quite unfortunate that preservation of life is not that much of an incentive for these companies. You know, I think with AIDS, it was global, but mostly affecting Africa.
Yes.
Whereas this is now affecting the Western countries on a much higher scale, right?
Yes.
And I think that it's just really quite unfortunate that we even have to argue and have to fight for the vaccine to be given, you know. So I think there's a moral issue for me. So it's going to be interesting to see how it plays out going forward.
Yeah, it's a very interesting point you make. You know, HIV affected probably Africa to a large extent and India as well. And, you know, possible biases and prejudices that came to play there, which is unfortunate. I think as I grow a bit older, I realize that the world isn't as happy as I thought it is supposed to be, you know. And very, very good points that you make as well. And, you know, I think the preservation of life is of utmost importance, and probably the number one right is the right to life. But yeah, very, very interesting topic, and I think this debate can go on for hours and hours and hours.
Because I also just think that, like, if people didn't see inequalities before, we're definitely going to see them now playing out if we haven't already seen it with the rollout. So it's going to be very interesting.
Yeah, well, thanks for that. Let's go on to Kimberly. I think Kimberly will give you the last chance. Yeah, you can move.
Yeah, maybe not so much an opinion, but kind of a thought on the topic. It would be interesting to look at the patentability issue in line with tax law as well, because we talk about the companies or the pharmaceuticals that are making the money, but I was thinking just in general that who they pay taxes to, and if there's any, you know, if that has any influence on it as well, because my understanding too is that most of the governments are buying the vaccines at the moment. So it'd be I don't think citizens that I know of are purchasing the vaccines. So it'd be interesting to see the whole financial play from a point of view of patents with tax, as well as to what benefits the nations. Just a thought.
Yeah, look, that's not something I've really considered, but it is a good point. And, you know, possibly there can be some incentivization in terms of like a tax rebate that could be provided as well to the pharmaceutical companies. So it is interesting. I know the South African government is doing all the procuring and purchasing of the vaccine. It's not coming from any private entity in South Africa. It's purely government that's doing that. But yeah, it is something interesting to have a look at.
Or even which countries benefit from, you know, the pharmaceutical selling selling the product.
It will likely be the countries where the base is for that company that will benefit the most, I presume. Okay. Yeah. So thank you all for your comments. As you can see, it's a very sadly we have to debate this topic, but it is a very interesting topic to have. And, you know, as I said, these discussions can go on for hours and hours regarding this as well. But thank you for all those that participated. So if we then move on to the next section of the patentabilities, we'll look at the extrinsic requirements. Sorry, just give me one moment. Okay, we'll look at the extrinsic requirements of patentability. Now, these are basically the legal standards or norms that are set in terms of the Act. And that is that the invention needs to be novel, needs to be inventive, and must be capable of being applied. So your utility requirement. And if we just have a look again at section 25(1), as you can see, very important, that a patent may, subject to the provisions of the section, be granted for any new invention which involves an inventive step and which is capable of being used or applied in trade or industry or agriculture. So now we're going to look at each of these in more detail. So we'll look at each of the extrinsic requirements in more detail. And the first being novelty, which is probably the most important standard in terms of the extrinsic requirements, because it is quite objective. And when a patent is attacked for its validity, novelty will probably be your first form of attack on the patentability. So later on tomorrow, when we look at the grounds of revocation, novelty is obviously there, where the option exists for somebody to invalidate a patent. And as I said, novelty will be, in most cases, the first port of call when trying to invalidate the patent. As you can hear, my voice starts to go a little bit more. Excuse me. So an invention must be new immediately before its priority date. Now, you need to understand what is the actual priority date. And your priority date is the date where the first application is made for the invention which is disclosed in that application anywhere in the world. Okay, so wherever that application is made in the world, the first application that is made is considered the priority date that relates to that invention for which a patent right is sought. So at that date, the invention must be new. And it is only deemed to be new if it does not form part of the prior art before the priority date. And your prior art is any disclosure of an invention anywhere in the world. So anything that is publicly available is considered prior art before the priority date of that invention. So if you look at section 25.5, it says that invention shall be deemed to be new if it does not form part of the state of the art immediately before the priority date of that invention. So section 25.5 defines what novelty is, and it is anything, or it is deemed to be novel if that invention does not form part of the state of the art before the priority date of that invention. And then section 25.6 then goes on to define what is prior art, or the Patents Act refers to the state of the art. Prior art, state of the art, it's all used interchangeably. But section 25.6 defines what is the state of the art, and it says that it shall comprise all matter. And that can be whether it's a product, a process, any information about an invention, literally anything that has been made publicly available, whether it is in South Africa or across the world. And there can be disclosure in any form, whether it's in printed media, any publication, so any written form, whether there is an oral description. So if I'm presenting to you, I'm presenting my invention to you, there's some oral disclosure of my invention. And that will also form part of the state of the art. Or any use in any other way. So any disclosure of of matter is considered prior art. So at the date of filing your application, it should not have formed part of the state of the art in order to meet the novelty requirement. And as I said, anything counts as prior art. So whether it's an oral disclosure, such as a lecture like now, or any presentation, and very important for those that are in the tech transfer offices or working at the universities, you know, there's often a drive by universities to see how many publications they can get out from the university, and a lot of researchers and professors that just want to publish their work because it helps with their ratings and their funding as well, you know. But by disclosing their improvements or developments or technology, whatever it is, it's becoming public knowledge. And if they haven't filed a patent application for something that is commercially viable, they would destroy their novelty and have an invalid patent. So just very important for those that are working in the tech transfer type of offices, that you know, the word is put out to any researchers or those working in you know, technological development spheres, that they obtain their filing dates before making any disclosure of the invention. And again, you know, apart from oral disclosure can be your written publications. So again, research papers, books, magazines, other patent applications, which is probably the most important one, for scientific papers. And just, you know, another list of examples. Yeah, disclosure on a website is also an important one, and probably a very common one now. I had a client who seek to file a design protection or design registration for a, I don't know if you know what a Transact plaster looks like. You know, it's just a plaster with medication embedded in it. But it was a similar idea, but the patch was in a very specific design, and they seek to obtain a design registration for the shape of the design that was applied to that patch. And unfortunately, after a quick look on the internet, it came to light that they had disclosed this prior to filing their applications and prior to the grace period that's permitted in terms of South African design law. And, you know, it's unfortunate that you have to tell the client, and look, it's unfortunate, but you won't have a valid design right here. So just things to keep in mind. And importantly, remember, this disclosure can take place anywhere in the world. It's not located to South Africa. And this standard of novelty then is what we refer to as absolute novelty. So South Africa has a very high requirement in terms of novelty, where there's no grace period allowed for any disclosure. It has to be absolutely novel. Rebona, you have a question for us?
Yes, thanks, Marco. I wanted to ask, so when can you disclose the invention? Is it once the application is filed, or once the patent has been granted, the registration is granted?
So it will be from the filing dates. So you don't need to wait for grant, because your rights will, in most events, be effective from the priority date, or enforceable from the date of application. So there's no need to wait for grant. So long as you've lodged your application at the patent office, you are then able to disclose. Because when the courts will assess novelty to consider what is prior art, they will look at anything before the priority date. Okay, so remember, if we have a look here, an invention is deemed to be new if it does not form part of the prior art before the priority date. Okay, so that is the most important date, and anything after that priority date is not considered prior art.
Okay, thank you.
Pleasure. Kagiso, over to you.
Hi, Marco. I just wanted to ask, with oral disclosure, how strict this is, because it almost kind of feels a little bit unfair. For example, if let's just say somewhere across the world, there's a lecture that happens, and you know, you're in another part of the country, kind of part of the world, and you don't know what was said in that oral presentation.
Yeah.
How strict are they about that?
So the courts have held, and I need to look into this a little bit more, but there has to be an enabling disclosure, and what that means is that disclosure should allow the recipient of that disclosure to enable them, or in a way, it must disclose it in such a way that will enable that recipient to perform that invention. So it has to be quite a technical disclosure in most cases. So just saying, I've got an invention for whatever it may be, it might not meet that requirement because it's not really an enabling disclosure. So it should enable the recipient to perform that invention. Okay. Okay, so novelty, very, very important. And if we then look at what the courts have held in terms of novelty, but in particular touching on Kagiso's question, what is meant by made available to the public? So if we just go back to section 25.6, it says the state of the art shall comprise all matter which has been made available to the public. So what does made available to the public actually mean? And the court looked at this in terms of the Macaulay Corporation case. Sorry, the fire alarm's just gone off at the office. So if I run, there's a reason. Just excuse me if I disappear.
I'm staying in the office, so you can run.
Sorry about the noise, everyone. The siren's going off. But okay, in Macaulay, in the Macaulay case, and CP was the Commissioner of Patents, it said that what is meant by made available to the public will depend on the facts of each case. And it said that if the invention deals with a highly technical subject, the word public must mean something more than the ordinary man on the street. And I think it means those persons to whom the specification is addressed. So, we've been talking a lot about pharmaceuticals, so a lot of chemistry and biochemistry that's involved there. So if I'm just telling the Joe Soap on the street about my invention, am I really addressing it to somebody that's going to have an understanding of what I'm actually talking about, or are they going to think I'm crazy? So the court actually has to look at who the audience is that you're addressing it to. So if it is somebody that is skilled in that art, that is a technical person in that specific field of technology, then it would likely relate to that person, but not to an ordinary man on the street. And then similarly, the question whether the material is available to the public would appear to cover the concept that it is available to the public anywhere in the world. And it is. Okay, we know that the Act clearly says it's anywhere in the world. And then it just goes on to state that the state of the art includes anything which is in possession of any member of the public, which he may disclose to others without any inhibiting fetter or confidence, whether express or implied. So there must be a non-confidential disclosure to another. Mere disclosure would not appear to suffice. Okay, so just very important, as the courts have held, if we just recap that what is meant by made available to the public is that it is addressed on a case-by-case basis, and the court would actually have to see who is the specification actually addressed to, and not just merely any person on the streets. Okay, then as with most things, there are exceptions, and in particular, there are a few exceptions to novelty, and it's twofold. It relates in different scenarios. So the first one is where there has been disclosure of an invention, but that disclosure doesn't destroy the novelty. So you will still be able to obtain a valid patent, even though there has been disclosure before the priority date. Then the other exception is where there is disclosure, but that disclosure is not novelty destroying. So, sorry, I've mixed this up slightly. So the first one is where there is no disclosure, but it is novelty destroying. So somebody has disclosed, but it destroys the novelty. And the other is where there is disclosure, but it does not destroy the novelty. And if we touch on these, sorry, I think we'll break at 12 o'clock for lunch. So if we can just push through until 12 o'clock. So the first exception to novelty, where there hasn't been any disclosure, but it does destroy the novelty of the invention, can be found in section 25.7. And this relates to prior patent applications. So if we have a look at section 25.7, again, very tiresome to read. But anyways, it says the state of the art shall comprise matter contained in an application open to public inspection, so meaning that it must be publicly available, for a patent, notwithstanding that the application was lodged at the patent office and became open to public inspection on or after the priority date of the relevant invention. if that matter was contained in that application, both as lodged and open to public inspection, and the priority date of that matter is earlier than that of the invention. Okay, so I'm sure all of you are very confused by what this actually says. Kagiso, you agree? Very bamboozled, yeah. But what it basically says is South Africa follows a first to file system. So the first person to file an application at the patent office secures the priority date for that invention. So say that there are two inventions that are identical. The first person to file that application has the right to the invention, but it has to become open to public inspection. So it has to become publicly available at a later date. If it doesn't, then it's kept a secret document and it will never be made publicly available. So in this case, where there are two applications for the same invention, the earliest filed invention, although it hasn't been made publicly available yet, will be considered prior art, provided it does become open to inspection at a later date. So if we just have a recap at the bottom there, we have written that it says, in other words, if there are two co-pending patent applications at the South African Patent Office, the one with the earliest priority date is considered to be novelty destroying in respect of the second later filed application, even though it isn't publicly available at the date of filing the second application. Okay, so I hope that makes sense to everybody. Okay, so we've got two co-pending applications for the same invention. The earliest date will be considered prior art against the second date, even though it's not available to the public as yet. Okay, if we look at the second one that falls under the, if we look at the second exception where there's no disclosure, but it does destroy the novelty, that will be found in section 25.8. And section 25.8 says that an invention used secretly and on a commercial scale within the Republic shall be deemed to form part of the state of the art for the purposes of subsection 5. Okay, so this is where an invention is used secretly, but also on a commercial scale within the Republic. Okay, so yeah, you can see that this exception only applies if the invention is being used on a secret and commercial scale within South Africa. So remember, a patent can relate to a method of performing something. So a method of manufacture, a process is also patentable. So it could be that there's a patent for the process of blowing up plastic bottles. They might be using that process secretly, but on a commercial scale within South Africa, then that will be considered prior art. Okay, so this relates to trade secrets specifically, where it is used secretly and on a commercial scale. And that is considered novelty destroying. Okay, is everyone with me so far? Okay. By everyone, I mean Kimberly and Kagiso, because I can't see anyone else. Okay, if we move on to the second group of exceptions, that is where there is disclosure, but that disclosure isn't novelty destroying. Okay, and that is your second medical use. So if we go back to the method of treatment type claims and where there's a first known use of a compound and a second known compound, in terms of section 25.9, that second medical use of a known compound or composition is not considered novelty destroying, provided that the use is new. So if we just have a read through section 25.9, it says, in the case of an invention consisting of a substance or composition for use in a method of treatment of the human or animal body by surgery or therapy or diagnosis, practice on the human or animal body, the fact that the substance or composition forms part of the state of the art immediately before the priority date of the invention shall not prevent a patent for the invention being granted. Okay, it won't be part of the state of the art. So this does allow for the permissibility of the patentability of a second medical use compound. And then lastly, if we have a look at section 26, where there has been prior knowledge or publication of an invention, which won't be considered novelty destroying. That is if there has been disclosure without the consent of the proprietor. You might still be able to obtain a patent for that invention if the disclosure was not with the consent of the proprietor of the invention. But there are certain requirements, and that is that as soon as you become aware of the unauthorized disclosure, you need to make an application for the patent as soon as possible after being made aware of that disclosure. So if we just read through section 26A, it says that if the patentee or his predecessor in title proves that such knowledge was acquired or such disclosure or use was made without his or her knowledge or consent, and that the knowledge acquired or the matter disclosed or used was derived or obtained from him or her, and if he or she learnt of the disclosure, use, or knowledge before the priority date of that invention, that he or she applied for and obtained protection for his or her invention with all reasonable diligence after learning of the disclosure, use, or knowledge. Okay, so hopefully you'll follow that one. So it's where there's unauthorized disclosure, you are able to still obtain a valid patent, provided that all reasonable diligence is taken to obtain the patent rights. And then lastly, section 26B, that would be where, as a result of the invention being worked in South Africa by way of a reasonable technical trial or experiment by the applicant or patentee, or the predecessor in title. So where there is a technical trial taking place or experiment within South Africa, that is, you are still able to obtain valid patent protection. So where there has been some prior knowledge to that medical trial. Any questions on any of these exclusions? Yeah. So I have briefly touched on how the courts would assess whether an invention is deemed to be novel or not. And the most important case that touches on this test for novelty is the Genturuko versus Firestone case. And what the court held there or provided was a 3-step test in assessing the novelty of an invention and establishing whether an invention is novel or not. And what needs to be done is that the claims of the patent have to be construed. So remember, the patent specification comprises generally various sections. Your first section would likely be your description, which will set out the background, what the problem is that is being solved, and then the disclosure of how you go about solving that problem, and then including any drawings that might exemplify the invention. But at the end, it is followed by a set of claims, and your claims are what the court will always turn to when assessing novelty, because the claims are what define the scope of protection. So it's what you as the proprietor of the invention wish to seek protection for, and how broad or how narrow your scope of protection is, and obviously the monopoly that is granted to you. So the claims are of utmost importance and what the courts use to define the rights that are granted to you. So the courts need to construe the claims of the patent, and how they will do this is they will break a claim up into its essential or into its integers. And they'll basically set out what is it that you're claiming? What is my shopping list of this claim? So, if we look at this bottle, it will be a body with a cap. Okay, so very basic bottle, cap. Those are my integers, right? So they'll draw up that, or they'll construe the claims in that manner. Then they need to consider what is the prior art. So they need to see what is the prior art, and they need to construe the prior art, and they will do that in the same manner. So they'll take a document that, or whatever disclosure it may be, but in most cases it will be another patent document, and they'll see, has this invention been disclosed in this prior art document? So does this document disclose a cap and a body? Okay, and then they need to compare the prior art with the patent itself, okay, in assessing the novelty. And if the prior art discloses both the body and the cap, then it will be novelty destroying. Okay, so you won't have novelty. So it's basically a comparison of what is claimed and what is in existence. And if all the tick boxes are ticked on both of those, then your novelty will be destroyed because there has been full disclosure. But say, for instance, we take this bottle, but this bottle has a handle, right? So your integers will be the cap, the bottle, and a handle. Let's just imagine there's a handle on the side. But the prior art only discloses the cap and the bottle, the body, sorry, but not the handle. Then you will have novelty because this integer of adding the handle to the bottle is considered new. Okay, so again, that goes on to what I said right at the beginning of the workshop, is that it doesn't need to be groundbreaking new. Provided you have one integer that is novel, your invention will be considered novel. Lufuno, you have a question for us? Lufuno, I can't hear you.
Marco, can you hear
Hi.
me?
Yes, that's better.
Okay, I'm saying that the example that you gave now about the cap and the box.
Yes.
Okay, so what if there is, I'm claiming that this is the new invention, hence the materials that have made the cap and then that has made the bottles are totally new and they do have some sort of benefits. Should I consider that as a new?
Yes, it's very likely. Look, you obviously have to assess in the bigger context of things. So the example I gave was a very rudimentary example, but if there is a process or manufacturing process for different material, that material that is new will probably be disclosed in the claim. So you'll have a cap. So let's use this as an example. So we have the body of the bottle, the cap of the bottle made of plastic, okay? But then you come along with a new type of bottle, a bottle and a cap, but it's made of glass. The bottle's made of glass. The material is different. So you can see that integer of the glass and the plastic don't align. So there is some novelty then that exists in a different type of material that is used. So it all depends on what the integers of that claim is and what you're comparing it to in the prior art. So yes, it does make a difference. Is that fine, Lufuno? Do you understand?
Thanks. Yes,
Okay.
I do. Thank you, Mark.
Okay. And then just what's also important is that when the courts consider prior art in terms of novelty, they'll only assess one prior art at a time, because there has to be a complete disclosure of that invention in a single piece of prior art. So I can't take two different documents and combine them to form a new document and find something that's novelty destroying there. Because then if you look at everything or all types of prior art documents, eventually all the integers will be disclosed. So you have to look at one prior art document at a time. And that is what the courts then refer to as mosaicing. So for novelty, you can't mosaic prior art documents. You can't combine two prior art documents to find whether an invention is novelty destroying or not, or whether the prior art is novelty destroying rather. Okay, we're nearly ready to break. This shouldn't take much longer. So that's novelty discussed. Any questions on novelty that you might have? Okay, no further questions. As I said, a very, very important section to understand fully. So if we then move along to inventiveness or non-obviousness, section 2510 deals with inventiveness, and it says that an invention shall be deemed to involve an inventive step if it is not obvious to a person skilled in the art, having regard to any matter which forms immediately before the priority date of the invention, part of the state of the art. Okay, you don't need to concern yourself with the last bit there. So just to go through that again, an invention shall be deemed to involve an inventive step if it is not obvious to a person skilled in the art, having regard to all the prior art that's already available. Okay, so if something is not obvious to a person that is skilled in that art, so this is where your expert witness will come into in court whenever the inventiveness is questioned, is because it must be addressed to the person that is skilled in that art, the patent specification, and whether it would be obvious or not to this person that is skilled in that art. But again, the courts only have to consider the opinion of the expert witness. It's not binding on the court. And as I said earlier, you know, it's a very subjective thing when it comes to inventiveness. And also the state of the art does not include prior South African patent applications or applications on secret commercial use. So this is just to give you an indication of what is considered prior art and what isn't. So when it comes to inventiveness, it doesn't include co-pending applications or applications used in terms of a trade secret. And also, as I mentioned earlier, lack of inventiveness is usually only considered when the claims are found novel. So in your attack on the validity of a patent, you'll normally attack it on more than one basis. So not just on novelty, but also inventiveness. So if it is found that an invention is novel, you then have the fallback position to argue that it might not be inventive because it is obvious to somebody that is skilled in that art. Nomkosi, you have a question for us?
Thanks, Marco. I just wanted to confirm that the exclusion of co-pending applications and secret use on a commercial scale for inventiveness is essentially the converse of the requirements for novelty.
Yes, that's correct, yeah.
And then my second question is there a definition for a person skilled in the art, or is this another subjective situation?
It's a subjective test again. But
Okay.
it would be somebody. Look, I think the courts have looked at what is defined by this, but that's really going into a lot more detail than what's necessary. Yeah, but that would somebody be that is, you know, au fait with that specific technology. You know, so if you're looking at the example I gave earlier of the case that we dealt with the LiDAR and the mines, you know, it would be somebody that is skilled with that type of technology or the LiDAR technology and how it is applied on the mines. So it might be an engineer, for instance. So just with novelty, as I mentioned, there's no possibility of mosaicing the prior art. But when it comes to novelty, all the prior art is considered. So everything that is publicly available. So when it comes to inventiveness, it is possible to mosaic prior art in order to determine whether that invention is inventive or not. Lofuno, I see your hand was up, but you disappeared again. Maybe I answered your question.
Yes, Marco, you did answer to the question. Thanks.
Okay, good. So how do the courts assess inventiveness? And this is the test that was set out for this is the Ensign-Bickford test. Genti-Rucco also sets out a test for inventiveness, but the test in Genti-Rucco was a 3-step test. And the Ensign-Bickford case, which was heard before the Supreme Court of Appeals, devised a 4-step test. So they went a bit above what Genti-Rucco held. But at present, the test that is applied for inventiveness is the one that is set out in Ensign-Bickford. That is the most recent precedent for inventiveness. And what the court needs to look at is, what is the inventive step? What is it that you're arguing is inventive about this invention? And that is the subject of the patent. And then they need to consider what is the state of the art. So they need to address what is all the state of the art at the priority date of that patent application. And then obviously to see, how does the step go beyond, or how does it differ from what's already known? You know, what is it that is said to be inventive above what is known? And then probably the most important is, would it be obvious to a person skilled in the art to be obvious or not? And this is where the expert witnesses will be called in assessing inventiveness. And I think we will call it for lunch. We can break for an hour, if that's okay with everyone, just to catch up with any emails you might need to catch up, to eat, and then we can resume again at 1 o'clock on the dot. But before we go, are there any questions on the topics that we discussed? Just remember that these are very important, so if you're unsure of anything, please rather raise your hand and ask the question now.
Marco?
Ah, yes.
Could you just type the name of the case that presented the 3-step test, just for reference purposes?
If you just go back, it's this case, the Genti-Rucco case.
Ah, okay, all right, no,
yeah,
thanks.
So they touched on both.
Okay, thanks.
No problem. Are there any other questions?
Marco?
Ah, yes.
Okay, it's Kangwell. I just wanted to find out, let's say, for example, I have 2 patents, and then the combination thereof of those 2 patents, can it be considered to be a novelty destroying, or it might not pass when it comes to inventiveness?
So it depends on where you're looking at it from. So if you're looking to see, is my patent novel, then there is a possibility of it being novel, provided that there's no prior art that discloses that combination. But if you're looking at it from an infringement perspective, the court can only look at one patent document as prior art when assessing novelty. But when it comes to the inventiveness, they can combine the 2 documents to see whether it is inventive or not. So it might be that the claims are held to be novel, but that it might not be inventive. Does that make sense to you?
So it might pass the novelty part and fail on the inventive part?
That's correct, yes.
Okay.
Yeah, so that combination, it could pass novelty but fail on inventiveness. It's unfortunate that I can't present the the PowerPoint presentation to you, because I have a video that actually highlights these topics quite nicely. But I'll try now in this hour to see if I can quickly get it up and running again, and then we can have a look at that. But I think for now, before we eat into more of the time for break, we will meet up at 1 o'clock again. And I hope this has been insightful for you so far and that you're actually learning quite a bit. Yeah. Okay, but let's break and then I'll see you at 1 o'clock on the dot. Enjoy your lunch. Welcome back, everybody. I hope you enjoyed your short break. And I think we can get going with the next section of the work. But before we do so, you'll see that I didn't touch on this last slide. It's just a very brief overview of the requirement of invention being capable of being applied or used in trade or industry or agriculture. That's just something you can read through in your own time. I'm not going to touch on that section at all today. As I mentioned earlier, I did want to show a video to you. I'm quickly going to try and see if it does work. Otherwise, we'll just have to skip it, unfortunately. Kimberly, because I can see you, would you mind just giving me a heads up if you can actually see this video or not, if it plays?
It's playing, but I can't hear any sound.
Okay. Is there any sound now? No sound.
Not that I hear.
Okay. It doesn't look like it's going to work. Sorry about that, everyone. But this is basically just a clip from the movie A Flash of Genius, where the inventor had invented the wipers for a motor vehicle, but for the two-blade wipers system, where there were two blades. And Ford basically infringed on his patent. And in this clip, they're arguing the novelty and inventiveness of this invention, really, which is really why I wanted to show this scene to you, because it actually captures it quite nicely. And the analogy that he uses is that of a dictionary. You know, he says you can read multiple different works of literature, you know, different books that have been authored by different authors, each having, you know, a different crowd that they're wishing to please, or a different audience that they reach out to in these novels. And he said, although the dictionary contains all these words, each of the books that have been authored by different authors are creative in their own right. And it's the same when it comes to patents, you know, just because there are these components that have existed previously, by putting them together, you get a whole different invention. So it was basically touching on that concept that I said earlier, you know, that an invention doesn't need to be groundbreaking new to be considered novel. Although as long as there is something that is an integer which hasn't existed before and is considered new. So unfortunately, that's not working through Teams. And again, one of the reasons why I don't want to lecture via virtual means. Okay, but then let's move on to the presentation again. It's that one. Before we continue with the next section of the work, are there any questions that you might have from what we've discussed this morning and into the early afternoon? Okay, it doesn't seem there are any questions from this morning's discussion. So we'll move on to this next chapter of work. Unfortunately, this section is quite boring, if I do say so myself. Okay, so it's...
Sorry, Marco.
Ah, yes.
Yes, did you deal with the third, is it a requirement capable of being applied? Did you already deal with it?
So I just mentioned it's this slide over here. I'm not going to touch on it briefly. I'm just leaving that to you to have a look at yourself.
All right.
I'm not going into it into much or into any detail for the purposes of this presentation, because in most cases the invention does meet the requirement of being applied in trade or industry or agriculture, and that's why I'm just skipping through that. As you'll see, there's literally only one slide in the presentation that touches on this. Okay, so if we move back to procedure, as I said, this isn't the most riveting part of the work, but it is vitally important. You know, the work that we do in patent law is very deadline driven, so it's highly important to understand these deadlines, to know when an application must be filed by, to know when a renewal fee must be paid by when you need to publish your acceptance in the patent journal. Because if these deadlines are missed, you can lose all your clients' rights. And you must understand that, you know, a lot of money has been expended in most cases in developing an invention, and not just money, but other resources, including time. So you don't want to fall in a situation where you've missed a deadline and you've lost their client their rights, because in some cases you can't recover those rights. You might lapse the application irrevocably, meaning that there's no remedy in order to salvage those rights. So although this is very administrative, it is a boring part of the work, but it is a very important part of the work. And especially to understand all the deadlines and the actual application process. So we've spoken about the requirements to obtain a patent, you know, but how do you actually go about obtaining that patent? And that's what this next section will look at, is this procedure in applying for a patent application and seeing it through to grant, and what happens during the course of prosecution. So unfortunately, again, the PowerPoint presentation isn't working because this is all animated, and it just works better to work through it one by one instead of having all these blocks up in front of you. But if we just look at my hand here, are you able to see this little hand on the screen? Okay. So we're going to be looking at two different ways of filing a patent application. So we're going to look at the way of filing a Paris Convention application. And then we're also going to look at the PCT phase of filing an application and seeing it into South Africa. So the first one is a very basic application that will be filed in terms of the Paris Convention or in terms of South African Patent Act itself. So in most cases, your client will come to you with their invention and inform you that they seek patent protection. So you'll consult with your client, give them the do's and don'ts, what is required. And in most cases, you will advise your client to file a provisional patent application. Okay, so a provisional patent application secures you that priority date because it's the first application that will relate to that invention. And that is the date from when novelty and inventiveness is assessed by the court. So remember that. Generally, your first provisional application will be the date that is considered your priority date. Once you file your provisional application, you have to then file a complete application, right? If we just look at this section on the top here, this is if this is all happening within South Africa. So forget the Paris Convention for now. Okay, this is purely in a South African realm. So the provisional application is filed at the South African Patent Office. And in this provisional application, there are various forms that need to be submitted. You need to pay the application fee, but you also importantly need to submit your patent specification. Now, you'll remember earlier I said a patent specification sets out what the invention is, how to perform the invention, what the background is to the invention, and then with a set of claims. But for provisional application, it's not necessary to include. Hi.
Are you projecting? Because I can't see anything on my screen.
I am.
Okay, because mine is blank, so I'm not. quite sure what the issue is.
Can the rest see?
Yes.
Seems as if the rest can see, so the problem might be on your side.
Okay, I'll log off and can you please admit me again?
Okay, I'll wait 30 seconds. Okay. Danielle, you're able to see that now? Okay, but let's continue then. So as I said, let's just consider this from a South African perspective. But for a provisional application, it's not necessary to file a set of claims. Okay, you only need to provide the specification itself, setting out what the invention is. And you need to describe it as best as you possibly can, because your complete at a later stage needs to be fairly based on what is disclosed in the provisional application in order to have a valid claim to priority, which is from this application here. Okay, so just remember, for provisional application, it's not necessary to file the claims, although often people do file the set of claims, but the claims are only required at the complete stage. Palesa, can you see the presentation now?
Yes, thank
Okay.
you.
Thanks. Okay, so when filing your complete application, you have 12 months from the provisional application within which to file your complete patent application. Okay, so you have 12 months. No rights are granted to a provisional application. You only have the right to priority that is granted to you. But your provisional application isn't what becomes the public document where the rights are vested. The rights are vested with your complete application. Okay, so a provisional application, if it isn't completed, nothing comes of it. You don't receive any granted patent rights. So you don't receive the right to exclude others to use the invention. You have to file a complete patent application. Okay, I hope everyone's following me there. As I said, once you file a provisional application, you have 12 months within which to file the complete. If it is a South African provisional application and you're filing a South African complete application, you have a 3-month extension available to you on request. But this only applies to South African priority applications where you're filing a South African complete application. So instead of the 12-month period, you have a 15-month period. But that 3-month period is not given to you as of right. You have to request that extension.